going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Hope you're having a great day so far. Happy Friday. Happy Friday. It's Friday. Yay. We made it to the end of a work week. Yay. Hopefully you guys had a good week and have great weekend plans. Yeah, that's about it. I don't, yeah. Intros aren't my strong point. First and foremost, I want to thank everyone for the donations to the Elmer Fudd Run. I do appreciate it. I'm going to put a community post out over the weekend with everyone's name that donated. I really do appreciate it. We were able to, let's see, I donated, I don't know, it was like $307, I think it was, total. So, yeah, we made the goal for both of my girls. They made their goals. Yay. Yay. The run was today. I haven't talked to them yet today though. So I hopefully they had fun. I will check in with them over the weekend. Anyways, I do appreciate it. You want to watch some court? I want to watch some court. Let's watch some court. All right, what I got tonight? I've got a bunch of random stuff tonight. We're gonna start with a case where a guy is trying to get his gun rights back. So I don't really understand the court procedure he needs to do to get it. But apparently, to be able to apply for to get it back federally, you have to go through your state first, and that's what this hearing is. So that's the first hearing. It's interesting and it ends kind of funny. Well, funny as court can be. What else do I have? I've got then I got a Judge Simpson kind of, you know, telling off a landlord who's clueless. Yeah, we'll just play it by ear instead of me just trying to remember what's in my video that I made like 4 hours ago. All right. We will start with the milestone though. A girl named Joe. Thank you so much for the 13 months. I do appreciate it. Congratulations and thank you. You're awesome. All right. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
25018-289 in the matter of Stephen Black.
All right, who's here?
I am here. Good morning, Your Honor. My name is Barton Morris. I'm appearing on behalf and with Mr. Black.
Good morning.
Morning. I first want to just apologize for not having a tie. I came to Chicago this morning and
I wouldn't have even noticed.
Well,
now I noticed. Yeah.
Great.
Well, so don't they sell ties in Chicago? They don't sell them there?
Not this time.
Not the kind that you would wear, Mr. Morris, right?
No, they don't even sell buttons in Chicago. Isn't that why Mike always has his buttons missing? Yeah, Chicago's weird, but we know that.
Yeah.
So
anyway, what do we got today?
Mr. Black is here on a petition that we filed to restore his firearm rights pursuant to MCL 28.424, wherein if we demonstrate to the court that he has paid all his fines and costs, it's been 5 years since he's paid all his fines and costs, 1. 2, it's been 5 years since he's completed the terms of his sentence, and 3, if we demonstrate that.
I use a service called Epidemic Sound. It's a giant music library for, a lot of creators use it. I think most people I know use it that have YouTube channels. But it's called Epidemic Sound. It's in their catalog.
He is not likely to be a threat to public safety, then this court can and should restore his right to possess a firearm. The brief that we filed last month illustrates that he had been convicted of operating while intoxicated third offense in 1997 and possession of a controlled substance in 2000, both in the Third Circuit Court.
What was the first conviction for?
Operating while intoxicated third offense.
Okay, and that was in 2000?
Correct. Oh, no, sorry, 1997.
Okay, all right.
Those are his 2 felony matters that he has on his record. Since then, he has not had, it's been 25 years. He's had nothing on no convictions for anything else. He owns his own business. He has a a lawn irrigation company, employs a number of people, actually has been taking care of me for many years, very well. And I don't think that there's any basis to believe that he is a threat to public safety. In fact, I think that it's very clear he'll be a non-violent individual. His prior offenses are both non-violent. And he is available to, or I can put it, you can put him under oath. I can ask him some questions, or he's available to take any questions from the court.
So I don't recall getting very many or even any of these petitions in circuit court when I was a judge, an active judge. Is it
Yeah, I can.
normally, I mean, is this something where you actually have to go to the gun board first and get denied? Is there someone that denied him his right to get it back or not? Was there an administrative judge? I mean, I don't have the pleadings, so I don't know.
Sure, I understand. First of all, these things don't come in front of criminal judges. I know you're a criminal judge for a
No,
while.
I was, but I
know.
was in the civil division for 5 years. I never saw
I
him.
know.
But go ahead.
The reason why is because many people think that it's not. First of all, no, you don't. This is not an appellate issue. This is a statutory remedy that provides that it does go in front of the court in which he resides, the circuit court in which he resides. The reason why you haven't seen them is because most people think that it's doesn't matter because you don't have the ability to be able to restore his federal firearm rights, and so therefore some people just think that this is kind of a waste of time. But the federal government now has implemented a program that's going to start soon that is going to permit him to restore his federal firearm rights, but it requires a state restoration first. And so that's
see.
the reason why you
And
haven't-
then is there, do you have to give notice to the prosecutor's office or to the attorney general's office? I mean,
I know
is there-
that is a normal question, but the requirement doesn't require that. There's no notice required, not like an expungement, of course, where we have to tell the attorney general or the county. There's the statute doesn't say anything like that.
okay, let me, Mr. Black, can you unmute yourself, sir?
There you go.
Okay,
Can you raise your right hand, Mr. Black? Do you solemnly swear to tell the truth, the whole truth, nothing but the truth?
yes.
Okay, put your hand down. Mr. Morris, why don't you ask a few questions and
All right, I just thought of something, and I'm gonna say this out loud, and it's kind of mean, but you guys are won't be able to unsee it. This guy looks like a combination of Homer Simpson and Bart Simpson if it was a real person. I can't unsee it now. I don't know why that came to my head, but now I can't unsee it.
establish maybe
Sure.
why
thank you.
I mean, you don't have to go through his whole history, but maybe establish why he needs the permit, what's it for, things like what's he looking, I don't know.
Sure. Just, I mean, and I'm happy to do that, but that is not one of the
Well,
statutory.
I know, well, I know, but I'm the one who makes the decision, so I get to
That's
we get
good
to ask
point.
those questions.
Good point. Mr. Black, was I correct when I stated that your only two felony convictions were that 2000 drug case and the 1997?
All right, let me ask him a few questions. Do you have any other felonies since then, sir?
No,
Do you have any misdemeanor convictions since then, sir?
no.
No convictions at all. Never. You've been.
Well, I have other convictions, but my last,
Wait, okay, so
conviction was-
let's start from the beginning of my question.
Okay.
Do you have any misdemeanor convictions since then? You said no. Now you're saying yes.
well,
What are you saying? Since your felony convictions,
okay,
have you gotten any more misdemeanors or felonies?
Yes.
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 Oh, okay. So tell me what you've gotten.
yes. So DUIs, I drank a lot, and my last conviction for that was. in
How many DUIs
2003.
have you had since your last felony conviction for operating while intoxicated, third offense? I assume that's what your conviction was for.
It was. I'm
Which
not
is a
exactly sure
5-year
of that number
felony.
off
You don't
the
know
top
how
of my
many you've
head.
had since then?
I've had a couple. I had a total of 8 in my entire lifetime.
Okay, I didn't ask that question.
Okay.
So, Mr. Morris, did you represent Mr. Black on any subsequent criminal cases?
No.
Do you know what his record is since his
I've
last?
patched his iChat, which we ran in
I don't know what an iChat means.
his.
Yeah, MB, when you said earlier you can lose your gun rights for nonviolent felonies, I mean, 8 DUIs. I'm guessing they took a lot away from him. 8 DUIs.
His Michigan State criminal record.
Okay, so
Is-
how many misdemeanor has he had since his drunk driving third offense? In other words, did he complete his OUIL third offense conviction, like probation? Was it completed successfully?
Yes, we
Yes.
attached that record
So
as well.
he didn't pick up any drunk drivings while he was on probation for drunk driving third? Is that what you're saying?
No,
Okay. And
I
you
see.
picked up drunk drivings that occurred after you were convicted of drunk driving third or subsequent offense, correct?
yes,
When
and
was
you
the
weren't
last
ch-
one?
And you weren't charged with OUIL third or subsequent offense after
No.
that?
no.
Boy, that's a really good
It's-
prosecutor there, huh? That makes no sense to me, Mr. Morris. Does it make sense to you? Man's convicted of OUL third or subsequent offense.
Are
Okay,
you sure that that's, I understand what the court's saying, but are you sure that that's true, Mr. Black? That's not on your record. So when's the last time you were convicted of an operating while intoxicated offense?
2003. And that's, if I can speak,
please.
I had a pistol license from 2010 to 2020. I've had federal things from that as well, where the feds had looked into my record. And in 2020, when I went to renew the second time, 2 of my charges had changed from misdemeanors to felonies. And if we look closely into my record, there's one of them on the attempted possession. The 3-digit code for the charge at the end makes it a attempted possession, which would be a misdemeanor. And that is still on my record. And that charge there is seen as a felony. And that's one of the charges that he's speaking to today. So I don't know.
But
I
he's
don't know.
asking about drunk driving, right? So like he
Yeah.
said, you were convicted of a drunk driving in 2003 and you were not charged as a felony, right? Is that correct?
Right.
Okay. How about anything after that? Have you been convicted of any?
What was, yeah, how about after that?
No, I haven't
Oh.
since 2003. I've been a Boy Scout. I had kids, raised, started a business, done all these things. I just
Well, all right,
No.
let's start with the drunk driving third offense. You had a drunk driving third offense and you pled guilty, sir? Back in what? When was that?
1996.
Is that true, sir?
that's what it says. My understanding is I pled them all down. That's how I continued to have misdemeanors.
So you didn't, so
it
you
doesn't
didn't
make
have,
sense to me
Hank,
either.
stop. You didn't have a felony conviction for drunk driving third offense?
They have
Your
it on
lawyer
there.
said your lawyer said you did. Is he wrong?
He's not wrong. That's on my record. Yes.
Well, you said you pled it down and there was no felony. Did you plead guilty to OUIL third offense in circuit court? Yes or no?
I don't recall pleading guilty. No.
Did you go to trial
Yes.
and you were convicted?
Yes.
And what was your sentence?
I don't recall. It's been a long time.
Okay, I'm going to deny the motion. You can, without prejudice, Mr. Morris, your client doesn't seem to remember anything. I can't make a value judgment on whether or not he is someone that should have a gun. Why do you need a concealed weapon, sir?
I'm not saying I need it. It's just a right. And
Okay.
I carry
You're
a
right.
license for 10
It
years.
is a right for those of us who follow the law. I'm concerned about you.
Understand?
If it's true,
Yeah, right, Judge? Yeah, it's an absolute right. You can lose them though. I really like this judge. He's filled in for I don't know the courthouse he's in, so but he keeps saying every time he has a docket online. He's like, oh, I've only got a few weeks left. He's retired, so we really got him for maybe another week or two, and then yeah, we're not gonna see him anymore. I really like him though. Cheshire Cat, thank you so much for the super chat. Taking care of sick kitten has a pelvis fracture. She is now home and doing well. Might not be on as much if you don't see me, but shall be lurking. All right. Well, hopefully the kitten recovers quickly. Cheshire, thank you so much for the super chat. Now go play Raid Shadow Legends while you're in your downtime, so you can level up your own Cheshire Cat. But I do appreciate the super chat. Thank you.
true that you pled guilty to drunk driving third offense and you can't tell me what your sentence was, let me ask you a question, sir. Did you go to jail or prison?
Yes. I've been to
Oh,
jail
you
several
did.
times for
You
drunk driving.
did, but you don't remember what your sentence was.
there would have been a 3 months, a 6 months. I've been to jail a couple times for this. I had a lot of
How many
DUI.
felonies, drunk driving convictions have you had? You would
One.
remember that day.
One.
One. And you don't remember what your sentence was. You don't remember how much time you got.
Specifically that charge, no, because I had several. I
Connor,
drank a lot.
Connor,
I have the register
I
of
did.
action. I can
All right,
share.
listen, Bart.
I'm not
Mr.
trying to be
Morse.
deceptive.
No, you're not. No, well, you're not. Well, I don't know about that, but
If
you're
we
not
don't know.
prepared for today. So I'm going to deny the motion without prejudice. You can renew it. And I want everything laid out. You've heard where I'm going with my questions, Mr. Morse. So lay it
Okay.
all out for me. And then once we all know what, I want to know what his sentence was from the OUL third, whether he went to prison or jail. He says he did. When he got out, how long after he got out did he pick up another drunk driving? And I don't know about this, having a CCW carrying a pistol after the fact. I don't understand how that could possibly happen with that record. But
Dan, that's what put it in my head. I mean, it's impossible not to see a name Bart and not think of The Simpsons. And then I looked at the other guy. I'm like, oh my god, he kind of looks like. Oh my god, just a domino effect.
I need to know more about that. That doesn't make sense to me.
I understand. I know it.
Now he's not. Now he said he can't get it, and he wants it because it's his right. Okay, well, all right. Anyway, motion's denied without prejudice. If you need to renew it, you can renew it. And I'm here. I will certainly hear it. If I'm not here, Judge Lillard will hear it. Fair enough?
Fair enough.
All right, thank you.
Connor.
All right, thank you, sir. Nice to meet you, Mr. Black.
Thank you.
Okay.
Calling case number.
All right, I think that one's on the attorney. He was not ready for the hearing. He should have been a little bit more prepared, which is kind of shocking because he seemed like the perfect attorney to have going into that hearing. He gave the judge the background on why he can file the motion he's filing. Seemed very knowledgeable. And then when it came to actually arguing the case, it's like, uh-oh. But he's in Chicago. Maybe he had too much Malort last night. That's a possibility. All right, we're moving on. What was next? I said it at the beginning. Judge Simpson case? Yeah, Judge Simpson case. Where he yells at a landlord. Kind of. And a Judge Simpson.
Kathleen Ivanoff versus Lauren Griffin. Hello, what's your name?
Kathleen Ivanoff.
Ivanoff. Okay. Lauren Griffin, they are not checked in. You did not pay for the second mailing or didn't do a second mailing, so I can't take a default today for their failure to appear.
Okay, he did get it. I just never put that piece of paper back to the court. I'm sorry. He got both.
What?
He got both.
She's not a Karen, but I feel like she gets a lot of things handed to her because she just expects Judge Simpson to just do this entire process for her. That's pretty much what this case is about, but I don't think she's a Karen.
Summons though.
No, but there's a mailing that needs to be mailed by the court.
It was.
And no, it wasn't, because my file reflects the second mailing. There would be three services, ma'am. There would be a service that's basically a service by a person. There would be a mailing, and then there is a second mailing in order for me to proceed today with a default. That second mailing was not done.
By the court?
You did not pay for the second mailing for the court to do that.
Okay, nobody told me I had to pay for a second.
Well, I get it, but it's just not there, so I can't do anything. The best that I can do, ma'am, is to adjourn this out. I will adjourn it to my next available day,
Wait,
which is
okay.
March 13th.
Well, can you please tell me what I have to do? Because I was not told that I had to do something else.
Not at this point that I'm aware of. And I can't give you legal advice. I can only tell you that for me to proceed by default at the first hearing, you would have needed to do what's called a second mailing. That wasn't done. So I can't proceed with the default today.
Okay.
I'm going to adjourn it to the 13th, 2026 at 3 p.m. That's an in-person hearing. Ma'am, on this date, how much are you claiming they owe?
Okay, wait a second. Can you please go back? I do not, you have to tell me how to do this second mailing. When I went to file all this,
You have to tell me how to, like, no. No, he doesn't. He just, no. How many times can I say no? No. No.
stuff, they told me what to do, and that was never part of.
They can't give you legal advice, ma'am. My clerks can't do that.
That's,
So you filed the paperwork, right?
yes,
And that's how the case gets on the docket. So from the paperwork that you filed, there was a service on the defendant, which would have, see what the service indicates. Actually, there was no service on the defendant.
there
So did you
was.
have somebody serve them?
Yes, yes. Yes.
Okay, that person, whoever served them, we do not have the return of service.
I know, that's
That's-
my fault. He gave it to me to take to the court, and I didn't do it. That's my fault.
Okay, so that's not here.
I get
The
it.
mailing would have been done by the court, the first mailing, which was done by the court. We did that.
Yes,
If you wanted to take a default the first time around, you would have had to pay for a second mailing, which would have been done by the court. That has not been done.
nobody told me that.
Well, ma'am, that's why people hire attorneys or read the rules. I mean, I don't know what my clerks can't give you legal advice.
Okay, as far as listen, I'm not trying to be argumentative. I've never done anything like this before. I've never dealt with the court. I've never had to do anything like this. I was following the instructions, and I thought I did what I was supposed to do. So I would not have thought
Ma'am,
of that as legal advice.
Ma'am, the case is started. So you did that. I just can't do certain things today because other things weren't done. But that doesn't mean the case is over. It's just, it gets adjourned out to a date.
Okay, so can you just, at least, who do I call, or who do I get in touch with to accomplish this through the court, this second mailing? And the other problem is,
Ma'am, I don't need the second mailing now. And the reason I don't need the second mailing is because
Oh, look at that face. Look, wait a second. We just wasted 10 minutes on the second mailing and you don't need it now? What is going on? You need to give me better advice, Judge Simpson.
the one hearing that the tenant would get, in essence, has happened today.
yes,
Okay, so I don't need the second mailing at this point. Let me put it to you this way. If you had come in, filed the papers, the normal mailing would have been done by the court. If you had paid for the second mailing and the second mailing gets done by the court, then I'd swear you in and I'd take a default today. That's what would happen. It wouldn't automatically be adjourned out. That wasn't done. So what happens is it gets adjourned out if the tenant's not here.
okay. So now what? You said I have to do this again?
Do what again?
Come back to court?
I'm setting it for March 13th, 2026 at 3 p.m. That is an in-person hearing. You'll need to come down to the court. They'll get notification of that hearing. If they're not here at that point, I can take a default.
Okay, he moved out. I have no idea where he went. And so if that gets sent to this address, I don't know how that's gonna work. And
He mentions it pretty much every time he takes a default when the attorneys file for a second mailing. But he says it so quickly that you could just you probably don't even realize it. But he says, what do you say? Okay, I see the proof of a second mailing. Would you raise your hand for a default? It's kind of how he does it. I don't really understand what the second mailing is. So they serve them, they provide the proof with the court, and then they have to pay the court to send another letter for, I guess that'd be serving them twice. So then they could take a default on the first hearing, but she didn't do the second part, so she has to take the default on during the next 2 weeks from now. Yeah. Also, what's up, Mamie? Good to see you.
So I still want the back rent.
I understand what you're saying, ma'am, but I mean, he's gonna have to have personal service for me to issue a money judgment, but, you know.
He got personal service. He got served. I can.
Ma'am, I don't know that because you didn't turn in the form.
I'm gonna bring it in. I'm gonna bring it in. I'll bring it in.
Okay, but you're telling me all these things, and I'm just telling you, there's nothing else I can do. I set the date. You come down here. If I have all of the paperwork, you'll get your judgment. But I don't know what you want me to do, and I cannot give you legal advice. I cannot walk you through this procedurally.
Okay. I'm not asking for legal advice. I thought it was.
Well, you are.
Straightforward.
And so I will see you on the 13th at 3 p.m. Thank you. Court calls the case.
That one was fun. That one was fun. All right, maybe a little bit of a see. I don't know. She just doesn't understand what legal advice is. She thinks he's given, judge giving her directive or directions on what to do. She doesn't think that's legal advice. She just thinks that's directions. But a judge can't do that. Anyways, okay, we'll call her Karen. That's a Karen. She can be a Karen. And yes, my Karen radar absolutely sucks, MB. Absolutely sucks. I've said that ever since I started my channel. I'll call someone a Karen. You're like, no, that's not a Karen. Then I won't call someone a Karen like this one. You're like, that's definitely a Karen. Like, okay. I don't know. It just sucks. Anyways, let's move on. This next one is thanks to, I believe, Lucy. Lucy sent me this. Happened earlier in the week. This one, you know what? I'm not going to say anything. I don't want to spoil it. I don't want to get you guys anticipating anything. But we're in Georgia. I'll tell you that. Let's go.
All right. Let me know when you're ready. You're ready. Okay. We're going to get on the record. This is position 1 on our calendar. It's 25 SC 003 256, State versus Charlie Daniels. Mr. Daniels, can you hear us?
Yes, sir.
Great. Are you at work?
Yes, sir.
Are you a fireman? What do you do with that jacket?
I do cement, concrete.
Okay. But you need to wear like reflective gear?
Yes, sir.
Okay, great. Mr. Daniels is reporting from work. Mr. Majeski, his lawyer, is here in court, as is the prosecutor, Ms. Smith. Mr. Daniels, before I hand things over to Ms. Smith for the plea, I need to make sure that you are willing to proceed virtually. You have a right to be here in court, but you can waive that right and appear from wherever you are. Are you willing to do that?
Yes, sir.
You also have a right to have Mr. Majeski by.
Can you imagine being with the name Charlie Daniels living in Georgia? Man. Every day of his life he gets a joke. I bet.
Your side so that you could consult with him privately if you needed to. He's in court. You are at work. Are you waiving your right to have your attorney by your side for the plea?
No, sir. You're right there.
Well, he is right there, but he's not right next to you. I need you to tell me it's okay that he's not right next to me. Is that correct?
Yes, sir. It's okay.
Okay. Now, I want to be clear. If you need to.
Charlie Daniels band did the Devil Went Down to Georgia. I'm not going to sing it. You guys don't need to hear that, but yeah. If you don't recognize the title of that song, if you just Google it, I'm pretty sure you've heard it. I don't know if it's possible to go through life without hearing that, but you're Canadian. When Heather and I talk about Canadian music, she's like, "Oh, every Canadian knows this. This is one of the most popular songs in all of Canada," and she'll play it for me, and I've never heard it before. So, yeah, I'm not going to assume that song is widely spread in Canada.
To speak with Mr. Majeski at any time privately, he'll just step right outside and give you a call on his phone, and you can say, "Hey, what's going on with this?" And he can give you whatever counsel you need. I don't think that'll come up in this process. But if you have a need to speak with him privately, just tell me that and we'll pause. You can drop off the call, talk to him, and then hop back on, okay? Last thing, I need you to let me know if at any point you cannot hear us or if at any point you have a question about what's going on so that I can answer that question. Will you do that? Okay, and make sure you speak up. Ms. Smith, you are up.
Thank you. Mr. Daniels, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name.
Charlie Raymond Daniels Jr.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given this morning?
No, ma'am.
How old are you and how far have you gone in school?
I'm 45 years old, ma'am. I went to the 12th grade, ma'am.
Did you graduate high school or you made it to 12th?
I just made it to the 12th, but I'm online doing GED right now, sir.
Great.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with his services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes, ma'am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
For the purpose of this plea, yes, ma'am.
Mr. Daniels, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 7 years to serve 5 months with the balance probated?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation?
I just kind of started laughing a little bit. The question: the state and the court are not aware of any outstanding warrants. Are you aware of any outstanding warrants? Why would you say yes to that? You just admitted that you don't know and the judge doesn't know. Why would I say yes to that?
And that the court can sentence you to the maximum on each charge and can run those sentences consecutively, meaning one after another.
Yes, ma'am.
It's an assault charge. They haven't got to the charge yet. They're just still reading them as rights. But yeah, you'll hear it in a second.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you are charged with a crime in the future, that this plea may be used to enhance that sentencing, even in a federal case?
Yes, ma'am.
Are you currently on probation?
Yes, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked based on you entering this guilty plea today?
Yes, ma'am.
And are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial. Do you
Yes,
understand
ma'am.
that those are the, okay. Counsel, are you satisfied your client understands these rights that they'll be waiving by entering this guilty plea?
Yes, ma'am.
Mr. Daniels, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 25 SC 003256, how do you plead to count 1, aggravated assault, count 2, possession of a firearm or knife during the commission of or attempt to commit certain felonies, and count 3, battery?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that that appeal procedure must be completed within 30 days from today?
Yes, ma'am.
I think this is the court clerk. I don't think this is a prosecutor. I don't know though. The prosecutor usually stands close to where the defense attorney is standing in this court. They have 2 tables there. I actually don't know what her role is, but I don't think she's a prosecutor.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Okay, thank you, Mr. Daniels. Your Honor, if this case were to proceed to trial, the state would show that on February 15th, 2023, officers responded to 3553 Fairburn Place Northwest, that's in Atlanta, Georgia, and also in Fulton County. They were dispatched to the location based on an injured person call. When the officers got there, they spoke with the victim, Miss Tamala Jones, who stated that a guy she met off of Facebook around 2 weeks prior to the incident attacked her. She stated that the defendant believed that he left his wallet in her car after they spent time together, and the defendant then came back.
Yeah, well, she's just reading the report, so she can say the state said this, and it doesn't necessarily have to be her. I still don't think it's the prosecutor.
To the victim's home and attacked her in her front yard, causing a knot on her head and swelling. When the officers got there, they followed up with the victim and was able to see the knot that she had on her head. And also the victim in this case advised that the defendant pulled out a silver and black gun and pointed it at her as he struck her with his fist.
It's just a sentencing. A prosecutor, their work is already done. I mean, they don't really have to do anything, especially if they have a report that's being read into the record.
At this time, the defendant was not apprehended because he left the scene. However, he was eventually picked up on January 3rd, 2024, where he was charged with the offenses we have before us today. Regarding the negotiated plea, and those are the facts of the case, Your Honor. Regarding the negotiated plea between the state and defense, we've agreed to a sentence of 7 years to serve 5 months with the balance probated. For count 1, a sentence of 2 years to serve 5 months. For count 2, 5 years consecutive. And for count 3, 12 months probation. For counts 1 and 2 to run concurrent. Regarding the special conditions of probation, the state is recommending that the defendant have no contact with the victim in this case, to stay away from the incident location, for the defendant to complete an anger management course, also for the defendant to complete 60 hours of community service, for the defendant to be gainfully employed, as he's employed now, so that shouldn't be an issue, for there to be a Fourth Amendment waiver, and lastly, Your Honor, for the defendant to pay the medical bills of the victim. It wasn't stated in the facts, but after this incident happened, the victim reported that she started to have seizures because of the attack that was made on her. Therefore, the state is asking for the defendant in this case to pay the medical bills of the victim. And I believe that there would be a restitution hearing in this case based on those medical bills that can be scheduled at a later time.
Got it.
But right now, that's all from the state, Your Honor.
Okay, thank you. Hi. Are you here for?
All right. You might be right, Jedi. That might be the prosecutor. Maybe she's sitting there because the guy's on Zoom and that's where the mic is. I don't know. But yeah, when she said that's all from the state. All right. All right, I retract. Still think it's weird. All right. We're just going to move on.
From pretrial? Great, you are? Bostic. Hello, Ms. Bostic. Can you share criminal history on Mr. Daniels, please?
Regards to Mr. Daniels, 23 prior arrests. He has 5 felonies. All of the convictions are more than 10 years old. His probation is from 2010 on 10 SC 88293. Robbery, 2 counts. Sentence 10/27/10, 10 years confinement, 10 years probation. 4 other felonies, 1 being an ag assault, 08. The other 2 are for drugs and criminal damage to property. He has an open case in Clayton for firearm during, firearm by, and Schedule 1 from 10/31/24. Nothing further.
And the most recent arrest would be that Clayton arrest?
No, for probation violations. And that was his last arrest was 12/27/24.
12/24. Okay, thank you so much. Ms. Simpson, I saw some in Odyssey arrests that.
Nope. No, you're the very first one to make this joke, Captain Science. Man, so clever. Yeah, you're late to that one, bud. You are.
Post-date the arrest for this, and it mentioned probation violation. Has Mr. Daniels already been violated for this conduct? Okay, so he doesn't face exposure here. And how much time remains on the 10 SC case?
He's actually got 2.
Oh, okay.
So he has a 09 SC 82922. He has 4 years remaining on that one.
Yep.
And the 10 SC 88293, he has 3 years left.
All right. Got it. Thank you. Mr. Majeski.
Yes, Judge, thank you.
All right. So we just went through all the boring stuff, all the background. I mean, he's got a colorful background. Listen to what the attorney says. This is why I put the video in here. Yeah, and just remember, you can thank Lucy for this, who isn't in the chat. She doesn't really hang out with us. Like, she doesn't come to the chat. Or she might lurk, but I think we're way past her bedtime. So, yeah. Good luck.
With the probation revocation and the time that he served before he got out on bond, according to the revised version of 17-10-11, he's done all the time that he needs to do.
Mm-hmm.
Subsection A, as you're aware, says, incarceration for any reason.
Mm-hmm.
So we should be good there. Judge, every time I come in here, I tell you about how much I like my client. I realize I've got a history of that over the past decade or so that we've known each other, but maybe it's because
So you've worked with Mr. Daniels throughout some of these things I've heard about?
Yes, Judge. I did the
Okay.
probation revocation. I've had a lot of contact with him. He's one of my guys. He shows up for his appointments. He returns my phone calls, which is rough
That's
currency
refreshing.
these days.
Yeah.
He's got a good job right now. We really appreciate you allowing him to appear via Zoom. Unfortunately, he had a spectacular wife that I worked with. Often I work with the spouse when they're in custody. She died in a freak accident. A brown recluse bite can be fatal.
Wow.
I mean, people talk about black widows like there's something that's just going to make you sick, but she got bit by a brown recluse and died. So he is now dealing with their 5 children by himself, supporting them by himself. He was lucky enough to get this good job. He's got a real good force at well. I mean, this man is he's got some substance. He takes pride in himself, and he's really taking pride in his ability to provide for his family. without the support of his wife, which she was amazing, Judge. You would have loved her. She's just one of those people you can't help but really like. I think this is a good resolution of this case, Judge. We were going to try it, but this is something that needed to be worked out based on the criminal history and discrepancies in the facts and everything.
Right.
Ms. Smith has been great to work with. Tough prosecutor, very good lawyer. It often helps when you have somebody like that you can work with to get to this resolution. I urge you to take this negotiated, Judge, all the work that's gone into this case and everything. I really think this is the appropriate result here, given this all the circumstances.
Got it. Okay. Mr. Daniels, first, I'm sorry to hear about what happened to your wife. That is tragic. Was it something where at least she was given medical care, but it didn't work out, or she didn't even make it to a hospital?
I was incarcerated at the time, so I didn't really have contact at the time because of Jackson. They don't have phones.
So that makes it even harder. You weren't there to help. I'm sorry to hear that. How old is your oldest kid?
My oldest kid, like 27.
And how old is your youngest kid?
Like 1 year old.
1 year old. Okay. So you got some still in the house.
Yes, sir.
Okay. All right. When did your wife pass?
Last year in June? Last year in June.
Okay. So you were serving your revocation time when this happened?
Yes, sir.
Okay. This case in Clayton, Mr. Majeski, are you handling that for Mr. Daniels?
Not yet. I imagine we'll probably get that tied up for him now.
Okay. What do you know about the case in Clayton, Mr. Daniels? I'm not asking about the facts. Don't tell me you did it or you didn't do it, but what are you charged with? Is it indicted yet? Have you gone to court?
I haven't went to court, and the case up there is like, it's beatable, but it's just like I didn't have no knowledge of something that was in the car.
All right. I told you not to get into that kind of stuff, but is it just gun or is it gun and drugs?
I think it's just gun.
Okay. All right. Well, you should know, and I know you know it, but I'm going to tell you anyway. You can't have a gun. You can't be around guns. You can't be in a car that has guns in it. You can't be in a house that has guns in it. So if your household has guns in the household, they may belong to your older children. They need to get out of the house. They need to not be in cars you're in. I don't know why you didn't get charged with felon in possession as well. The state should have charged you with another felony. And I'm not encouraging them to do that. We're working the case out. But I assumed when I read the indictment, like, hey, this is a guy with no criminal history, because you were charged with possession of a firearm during commission of a felony, but not the offense that I typically see along with that, which is, and this guy shouldn't even have had a gun because he's a convicted felon. Then I hear from Ms. Bostic, you got 5 felonies. So I'm not saying you had a gun on February 15th when you got into it with Ms. Jones, but you better not have one going forward. If you and I are together in the next few years and the arrest is, it was just a gun, I didn't shoot anyone, it's going to be prison time for you. And you don't need that. Your 1-year-old doesn't need that. So carry a baseball bat, carry a magic wand, but no firearms. Understood?
Yes, sir.
Good. Or whatever you use with cement. Carry a cement weapon, but no firearms.
Here, let me give you the list of all the weapons you're allowed to carry. I love the magic wand too. Yes, do that. Yeah, in Atlanta, just bust out the magic wand. People will be running away from you. Absolutely.
Do you have questions about any of the things we discussed about you or your case?
No, sir.
Ms. Jones, it sounds like you had only known for just a few weeks. Is that accurate?
Yes, sir.
Okay. Have you had any contact with her since this incident?
No, sir.
Okay. So it sounds like it'll be easy to stay away from her. Well, Mr. Daniels, I find there's a factual basis for your plea. I hear Mr. Majeski loud and clear that there are probably 2 versions of events as to what happened, and it ultimately would result in a he said, she said, because there weren't witnesses to whether you pulled a gun or not. But it sounds like the young lady did have a big old lump on her head, and those don't just grow there. So I understand why you're wanting to work this out. I find that your plea is knowing and voluntary. Knowing means you understand what's going on. It's not your first rodeo. And voluntary means that after you've had a chance to think about it and consult with your lawyer, you've decided this is the right way forward for you. Is that a fair?
Can we break something down real quick? my math isn't mathing. Something's not adding up here. So his wife passed away from the spider bite in June while he was incarcerated. So that happened in June, last June. That's what, 8 months ago? Since he got out of prison, he met someone on Facebook, and I'm for what it sounds like, it was kind of it was a date because he lost his wallet in her car, and that's what caused the altercation, I guess. If his wife was that spectacular, he's moving on very quickly. I could be reading into this wrong, but yeah.
Statement.
Yes, sir.
Mr. Majeski, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith, can we sign for you?
Yes, Judge.
Mr. Daniels, is it okay if we electronically sign your name to the indictment indicating your guilty plea?
Yes, sir.
Okay. Here's what I'm gonna do. Oh, let me ask one more question of Ms. Simpson. Did Mr. Daniels get revoked in both cases? Okay, because I'm gonna try to close those out, but I really can't because this plea doesn't, they'll just all run concurrently with each other. All right. You're only gonna have one probation officer. Where do you live, Mr. Daniels? What county?
Living alone.
In Fulton County or DeKalb County?
Fulton County.
Okay. All right. Well, you're going to be on probation as a result of this case. So you're actually going to be on probation for 3 cases. That doesn't change a whole lot for you other than that you could be revoked in 3 different cases if something bad happens, which I hope it does not. But for this case, your most recent one, I'm sentencing you on count 1 to 1 year to serve 5 months with the balance probated. Count 2 is 5 years. It must run consecutive to count 1, and I will probate that. And count 3 is 5 months to serve, and that'll run concurrently with count 1. So it's actually going to be 6 years to serve 5 months. I'm knocking 1 year of probation off. 5 years from now, you and I aren't going to be doing it. If you're going to mess up, it's going to be soon, and we don't need to have probation hanging out there forever. You got forever on probation in these other cases, and it would be fine by me if at age 50 you're not on probation anymore. So let's have that be your goal. When you cut that cake with 50 candles on it, my hope is there's not a probation officer there with you asking for a slice, okay?
Thank you, sir.
Well, that's on you. That's up to you to make that happen. Special conditions of probation. This is where the work comes in for you. Number 1, the obvious one, no contact with Ms. Jones. Don't look her up online and say you're sorry or I'm going to get you or anything like that. Also stay away from that address on Fairburn Place. You live anywhere near there?
No, sir.
Okay. You're going to need to get your GED within the first year of your probation. Sounds like you're already underway. You got 1 year to finish. What's the hardest subject for you?
Yes, sir.
What are you finding to be the most difficult subject as you get your GED?
History, not really like science.
Okay, well, you got a year to work out the science part. You have to do 60 hours of community service. Those you need to complete within the first 6 months of your probation. And I'm front loading all this so that you're more likely to have your probation officer say, well, you've done all the things you needed to do. Let's close this out early. You'll need to take an anger management course within the first 6 months of your probation. And we will reconvene if the state files a motion to talk about restitution. There's no dollar amount in front of me right now. Mr. Majeski hasn't had a chance to evaluate any medical bills. But if Ms. Jones does provide medical bills, Ms. Smith will get those to Mr. Majeski. And if we need to have a hearing, we'll have it. It may be that he doesn't want to contest it on your behalf. But for now, I won't put anything in there on restitution. So that is the situation. Ms. Smith, anything else from the state? You sure? You paused. Did I miss something?
No, well, did we talk about the Fourth Amendment waiver and community service or?
I got community service. I forgot about the Fourth Amendment waiver. And all that Fourth Amendment waiver is, Mr. Daniels, is that if probation is working with you and like, wait a minute, you've been acting kind of funny and want to search your car, they can search your car. They don't need a search warrant. But since you're not going to have a gun in your car, that's not going to be a problem. Mr. Majeski, anything else on behalf of Mr. Daniels?
No, Judge.
Mr. Daniels, you got any questions for me?
No, sir.
All right, Ms. Simpson, who you can see in the background, can you wave, Ms. Simpson? There she is. That's Ms. Simpson. She's with probation. She's going to give you some reporting instructions about probation, okay? Listen up.
Cabinet Science, I think you have to do it by subject. So I think, you have math, history, science, I don't know, English. I don't think it's just one giant test. I think you have to pass the equivalent for all the subjects. I don't know. I don't know if I know anyone or like I'm friends with anyone that has a GED. And the people that I've met that has it, I didn't really ask questions, so I don't really know what it entails either.
Good morning, Mr. Daniels. Can you hear me?
Yes, ma'am.
So do you still currently reside on Wyndham Way?
Yes, ma'am.
Okay, so you need to contact your officer, Officer Flemister, on Monday, this coming Monday,
Yes, ma'am.
okay? Remember where the office is?
Yes, ma'am.
All right, contact your officer on Monday so she can advise you whether you need to actually come in or not.
Yes, ma'am.
Thank you.
All right, if there's nothing else, Mr. Daniels, good luck with everything. Single parenting can be challenging. Hope you're managing all that.
Yes, sir.
All right. Thanks, everyone.
Thank you, Judge. Judge, I believe that completes my business with you.
All right. I hopefully he gets through it. I mean, he's got a lot of kids to take care of. That was the sad story about his wife. And then like I started putting together all the dots. Like, this isn't adding up. But when I first heard that, I was just like, Lucy, why would you send it to me? Because I kind of felt sad. I felt sad, and then I was, really rooting for that guy. I was like, I'm gonna play this on live. Yeah, you're welcome. Okay, we're gonna move on to the last case. We are jumping to Judge DeSanto's courtroom, and if you guys, I'll give you a little recap. I played a video. I think it was last weekend, maybe, where there was a bonding company that withdrew from the bond without a court order, and then Judge DeSanto ordered the guy to turn himself in or pay the bond. So that hearing happened, and we're about to see part 2 of it. I think I recapped that pretty well. Yeah, bonding company withdrew without the court order, which they're not allowed to do. You can't do that. Okay, let's go.
But this was by way a motion or a hearing of sorts for the bail bonds company, A1 bail bonds. And and I can bring everybody up to speed if you're not already up to speed in just a moment. So I don't know if I don't think that the defense attorney nor defendant were notified to be here, but Mr. Wood.
No, they absolutely were notified to be here. Yeah, you spent 10 minutes going through the attorney's schedule to make sure he could get there on time, just for him to agree to the original date you set. So no, he knew. They just didn't show up. That does not come back up during this entire hearing, though.
What? Oh, sorry. I didn't realize you'd already made your way up this way. Your name for the record, please.
Yes, good afternoon, Your Honor. Raymond Woodburn with A1 Bail Bonds.
Okay, thank you. Can you please spell your first and last names for the record?
RAYMOND
Okay, very good. Thank you. I'm going to have you please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
Okay. So I just wanted to be clear that I'm not necessarily looking to hold you in contempt. I just wanted to place a few things procedurally on the record with how things occurred with Mr. Durant. There was, because I think there was a misunderstanding somewhere that this court revoked bond and this court did not revoke bond. Mr. Durant was arraigned on February 6th in this court, whereby this court ordered a $10,000, 10% cash surety, 10% bond. Mr. Durant, I believe, was then transported down to Wayne County Jail, whereby the bond was posted in surety bond. Would that be accurate so far, Mr. Woodburn?
Yes, Your Honor.
Okay. Then February 17th, we were notified that Mr. Durant was in Wyandotte custody at the Wyandotte Police Department, which shares a building with the court. And that there was some understanding that the court revoked Mr. Durant's bond. There was apparently a drop-off by the bail bonds company of Mr. Durant to the Wyandotte Police Department. And with a copy of the next date. And so then you sent an email indicating, good morning, this is Raymond Woodburn with 81 bail bonds. I'm sending this email in regards to Luke Durant, case number 26161. A1 bail bonds was informed that Mr. Durant was not going to appear in court. He was no longer in contact with our agency, did not comply with bond conditions, and will not accept or return calls made to him by A1. For these reasons, we are respectfully requesting to be released from the bond at this time. I've attached proof of incarceration.
All right, that we were informed that he's not returning to court, and he's not returning our phone calls. So, if you guys don't remember, this dude's ex-girlfriend or some woman that he was familiar with paid his bond, and then they had a falling out. So she went back to the bail bonds company that she paid for and requested the money back. So, still, he's not going to return to court. Well, did he miss a court date? Like, how do you even act on that?
A bond discharge form, please have signed and emailed back. And then this was a thank you and thanks for your assistance, and this was an email sent by you, correct?
Yes, Your Honor.
Okay. Then there is a state of Michigan in custody form that was signed by somebody with Wyandotte Police Department. And then there was a bond discharge form sent over to this court. So here is where this court had concerns. Pursuant to MCR 6.106, you did reference that regarding termination of release order, paren 1. However, there is
he showed up to court. He showed up to a court date that was an emergency hearing, so his attorney was able to call him and get him on Zoom real quick, and he showed up to that one. And the judge ordered him to he had to go turn himself in or pay the bond that the bonding company withdrew, and he did it. So it was like none of that makes sense. The bonding company story does not make sense.
Some language missing. Further, the note on here that indicated bond revoked the court didn't have a motion before it to release A1 bail bonds from the bond. The court did not revoke the bond, and it appears from the bond discharge form that was filled out was that somebody informed you that Mr. Durant was not going to appear in court, did not comply with bond conditions. I'm not sure what those bond conditions were. We didn't have anything in writing that there was a violation or whatnot. And so Mr. Durant was in custody for about 24 hours, I presume. And there should have been a motion or an immediate motion or something filed with the court that would have then released your company from the bond or the surety? Because I don't see, sir, where the bail bonds company had authority to revoke a bond when there had not necessarily been, there was not a missed court date as of that moment, or that date, and I don't know what bond conditions were not complied with. And the statute indicates that there needs to be a hearing in that regard. And there was not any documentation filed by the surety company. So that's what we have this hearing for, just for clarification, so that there can just be a clean procedural record of that.
Yes, I understand.
Was there a motion filed with the court, or is there a request filed in writing with the court to release A1 bail bonds from the surety?
No, I was not aware that a motion had to be filed. What I sent for is what I normally send all the courts that I normally deal with, and I do apologize. This is my first time in contact with Wyandotte Court.
Okay.
So I did not know your procedures, and I should have asked.
That I don't think that's just Wyandotte. I think that's the entire state of Michigan. Just
Okay, well, they're not just necessarily the court's procedures, they're the procedurals pursuant to statute and court rules. So, if there's a request to revoke bond, sir, then we can hear that request to revoke bond. But then I think that there's some there was some misunderstanding somewhere that the court revoked the bond for Mr. Durant, and this court did not revoke the bond.
That was explained to Mr. Durant numerous times that evening that he was picked up. The reason for the revocation is the indemnitor, the person that signed on the contract to bond out, not only called us and told us he was not going to be attending court, but conditions that happened beforehand, he was requested in the contract to meet with our agent within 24 hours of his release to fill in the rest of his paperwork and sign his contract, which he never did. He would not be in contact with our agency, and he would not return any of our agent's phone calls. So that compiled with the phone call that we got from the person who actually signed that bond for him, saying he was not going to return, was going to put us in liable. So my agency wanted the bond revoked, so we went out for a vote.
Okay.
So it's technically a civil matter on that end. You're right.
Right. So, in review of the statutes and the court rules, which I had all pulled up the day this was all happening, and somehow my notes have gone missing. And what was the portion of the contract that he had violated, sir?
Non-contact with our office and not completing the contract with our office. He is required to stay in contact with A1 bail bonds.
Okay.
He is required to meet with one of the agents within 24 hours of release.
All right.
And on top of, I apologize.
No, go ahead.
Then on top of that, the request that we got from the person who signed on the bond and paid for the bond to be released from it because he was not going to go show up to court.
Okay. So it appears in reviewing the statutes and court rules that once the person's back in custody, then as you did, you notify the court, and then there has to be another process, there's additional steps to the process. And that the court would then have to grant that revocation of bond and release A1 bail bonds from the bond. And so I wanted the record to be clear that this court did not revoke the bond because there seems to be, like I stated, some misunderstanding that this court revoked the bond. But we did not have any hand in that, and that was between you and the signer or the poster of the bond.
Yes, Your Honor. And once again, it was explained to Mr. Durant at least 5 times on the way from his house to the jail. And it was also explained 2 days later when he was released, that the court had nothing to do with this, that the bond was revoked, and the reasons that I gave to you were the reasons why the bond was revoked.
Okay. And so then, just for the record, you have now been released from the bond, and Mr. Durant has posted a $1,000 bond. The court ordered Mr. Durant to post a $10% bond, just to ensure that there was in fact a bond posted, because then at this point, what happened was, if A1 bail bonds revoked the bond, then there wasn't necessarily a bond in place. And so the court ordered a $10,000 10% bond. So Mr. Durant did appear at a scheduled court date, and then the court ordered Mr. Durant to post a $10,000 10% bond. I don't know who stated he wasn't showing up, but he showed up. So, okay.
I'll say, Your Honor.
All right, yes. And I would just suggest just confirming the court rules and statutes before that happens again, but,
Yes.
okay. All right, thank you.
Yeah, Judge DeSanto, I thought she was going to be mad. I guess this is the first time it's ever happened to her. I've seen it happen to Judge Webster, and Judge Webster flipped out. I mean, it's a pretty big rule in the bonding world. You can't just revoke a bond. The court has to. How many times have we seen bonding companies in court asking judges to let them off the bond and they get rejected? I mean, I think I've played 3 or 4 videos of that in the last couple of months. Judge was like, "Oh, we didn't know. Okay, no harm, no foul." Yeah, and the guy wasn't even honest. Well, we don't know. Maybe he's being honest and the attorney for the defendant wasn't. But during the video, there were some facts that were stated that were not the same. The ex-girl, I don't know, the ex-friend had to pay $500. Like that was an important fact that they put on the record. She paid $500 to get taken off. Like, she already put her name on the paper for co-signing for him, and then she had to pay $500 to get him to go turn him in. Like, I don't know why that didn't come up. And then this guy said, I was very clear with them that the court has nothing to do with it, but it needs to. Like, I mean, this is I do not believe this is this guy's first day on the job. This is A1 bail bond. It's like one of the biggest bonding companies in Michigan. You hear it from almost every court. So they knew what they were doing. Maybe they're used to some judges will just sign off on it without a hearing. I don't know. Anyways, that's all I got. That is all I have tonight. Thank you guys so much for hanging out with me. I do appreciate it. Thank you for the membership milestones and the super chats. You guys are awesome. Let's see who's on. Who is on? We've got Lone Wolf, KDZ, KFAR, and Mike. I don't know who to want. All right, hold on. Did you guys already? Well, all right. Yeah, first one is Lone Wolf. Lone Wolf was said. Wasn't a mod. I didn't want to say it because I knew the mods were going to be ready for the question. But I didn't even have to ask the question. All right, we'll go to Lone Wolf. You guys win. All right. All right. It's set up. Have a great rest of your evening. Have a great weekend. Tomorrow night, state night, I will not be on. I've already got 2 videos set up for tomorrow, so I can actually take a real day off. I'm doing absolutely no court tomorrow. I'm going to stay as far away from my laptop as possible. I need a break, guys. I'm a little burnt out. I've worked my butt off the first 2 months of this year. I mean, I've put out almost 2 videos and 1 live stream every day since January 1st, besides Saturdays. But Saturdays I'm still putting out videos. I just need a complete day with no court. Yeah. So yeah. So I'm gonna have a great Saturday. Hopefully you guys do too. Go tell Lone Wolf I said hello, and I will see you guys Sunday night. Okay. That's it. That's all I got. Goodbye.
Thank you very much.
Do that. Thank
All
you.
right, have a good day.
Great day.
Thank you. All right, let's go off the record for a moment.